We are excited to offer probate services in Edmond, Oklahoma. A majority of probates are administered in long form and they take several months and even years if the parties, the family, are not in agreement. For lack of a better word, I call them regular probate proceedings. The attorneys will first determine if there is a last will and testament, a pour over last will and testament, or no last will at all. If the decedent died without a last will, this is called dying intestate. The lawyer will draft an initial petition for probate, just like in a summary. If the client agrees with the wording, then the law firm will have them sign that petition and will file that petition for probate with the court clerk. The judge will order that that petition be heard at some future date, usually at 30 days into the future. Probate lawyers will publish notice of the hearing in the local newspaper and will mail a copy of the notice of hearing to all interested parties. This is usually done by certified mail, so first we can prove that they got it, and second that we actually tried to mail it to them. At the initial hearing, the court will usually make 4 determinations at that first hearing. The first one is, does the district court have jurisdiction to hear this matter? If your loved one did not live in their county, then the court might not have jurisdiction. If your loved one did live in the county, had a house there, then that court probably does have jurisdiction. Number 2, is there a valid last will and testament, and should it be admitted into probate? Number 3, who should be the personal representative of the estate? The personal representative is usually a family member and is usually also the person who hired the probate attorneys to file the petition for probate. Number 4, who are the legal heirs, or sometimes called the beneficiaries of the estate? The judge will issue an order stating exactly who the legal heirs are. This is important because the legal heirs now have the legal authority to consent to the sale of real estate belonging to the estate. It's also helpful to know whether the estate is going to be split up 4 ways or 3 ways. Once the court has made those 4 determinations, it will usually appoint the petitioner as the personal representative. A personal representative is sometimes called an executor, just depending on where you live. This personal representative is charged with administering the estate of your loved one. This involves gathering and identifying all of the assets, settling claims, administering the estate, and finally distributing what's left over to the heirs. Depending on where you live, creditors usually have 60 days from the filing of the notice to creditors to file a claim against the estate. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of the decedent, your loved one, again by certified mail. If a creditor files a claim against the estate, then the personal representative decides if it is a valid claim and should it be paid. That claim then must be approved by the court before any payment can be made. Next is general inventory, and this is usually the list of the estate's assets. This list usually includes what is in the estate, such as personal property, mineral interests, real estate, and financial accounts. When real estate or personal property needs to be sold or to satisfy debts or to make money available for distribution, the personal representative will make an application to the court for authority to sell assets like real estate and personal property. Again, the judge must approve this. Earlier, I stated that the court determines the legal heirs of the estate at the initial hearing on the petition for probate. Because the judge has made that determination, all of the beneficiaries, the heirs, have the legal authority to consent to the sale of real estate or personal items by the personal representative. They have to give their permission to the personal representative. And if they do, then the personal representative usually sells the house with a realtor and deposits the proceeds into the estate bank account. This is a separate estate bank account. It's not the bank account that your loved one had during their lifetime. Once the personal representative has gathered all the assets, paid and settled all the claims, then and only then is the estate ready for closing. This is usually done by a final account filed with the court. Notice of the hearing for that final account is again published in the newspaper, mailed by certified mail to all interested parties, and usually set at some future date, like 30 days into the future. So as you can see, if everything goes perfect, a probate will usually take 4 to 5 months. Well, they never go perfect, and they usually last 5 to 7 months. If the family starts fighting, then it might even take years to complete. We have had that happen on a regular basis where the family just can't get along, And it takes years because it's hard to get onto the judge's schedule for all of those hearings we have to have about the fights. So the best thing you can do is get along with your family, at least during the probate process. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.